I have watched surveillance systems evolve before, not through legislation, not through public debate, not through any process that requires a government to announce what it is building or to ask permission before it builds it. I have watched them evolve through capability, through the quiet accumulation of technical ability that outpaces the legal frameworks designed to constrain it, until the framework and the capability occupy such different territories that the framework no longer describes what is actually happening. We are in one of those moments now. The instrument is called a geofence warrant. The mechanism is precise in its simplicity. Law enforcement identifies a location and a time window, a bank robbery at a specific address at 2:14 in the afternoon, a shooting in a defined city block over a 30-minute period, a protest site on a specific date. They present that location and time window to a court and request an order directing a technology company, Google primarily, which maintains a database called SensorVault containing location records for hundreds of millions of devices, to produce the anonymized location data of every device present within the defined geographic boundary during the defined time period. The company produces a list. Law enforcement examines the list, identifies devices of interest, and returns to the court to request the de-anonymization of those specific devices, the conversion of anonymous location signals into names, addresses, account information, and identity. The individual whose device appears on that list has not been identified as a suspect. They have not been observed committing any crime. No officer has articulated specific, individualized facts connecting that person to the incident under investigation. They were present, or their device was present, within a geographic boundary during a time window. That is the entirety of the basis on which their data was collected. The Fourth Amendment to the Constitution of the United States prohibits unreasonable searches and requires that warrants be supported by probable cause, describing with particularity the place to be searched and the persons or things to be seized. The founding generation wrote that language in response to a specific instrument of oppression they had experienced under British colonial authority, the general warrant, which authorized searches of unspecified persons and locations based on generalized suspicion rather than individualized evidence. The geofence warrant is the digital general warrant. It does not target a person. It targets a space. It collects data on every individual present in that space during the relevant period and works backward to identify persons of interest from the population it has already swept. The probable cause, to the extent it exists at all, attaches to the location and the time, not to any individual whose data is collected. Federal courts have been working through this question with the urgency that the scale of the practice demands. Google alone reported receiving more than 11,554 geofence warrant requests in 2020. That figure represented a five-fold increase from 2018, when the practice was still in its early adoption phase among law enforcement agencies. By 2021, geofence warrants had been used in investigations spanning bank robberies, homicides, kidnappings, and, critically, the January 6, 2021 events at the United States Capitol, where investigators used geofence data to identify individuals present inside the building during a specific time window. The Capitol investigation made the scale of the instrument visible in a way that previous uses had not. The geofence boundary drawn around the Capitol building during the relevant period captured location data for thousands of devices. The investigation that followed involved the systematic de-anonymization and identification of individuals based on their physical presence, or their device's physical presence, in a defined location during a defined time. The Fourth Circuit Court of Appeals in United States v. Chatri, decided in 2023, ruled that the specific geofence warrant used in that case was constitutional. The majority's reasoning relied on the third-party doctrine, the principle, established in cases from the 1970s, that information voluntarily shared with a third party carries no reasonable expectation of privacy, and therefore the government may obtain it without satisfying the full Fourth Amendment warrant requirement. The location data, the majority reasoned, had been shared with Google through the operation of location services on the defendant's device. The dissent in Chatri identified the structural problem with that reasoning immediately. The third-party doctrine was developed for a world in which the information shared with third parties was discrete and specific: a bank record, a phone number dialed, a specific transaction. The doctrine was not developed for a world in which a single company maintains continuous, comprehensive location records for hundreds of millions of individuals, updated at intervals of minutes, covering every movement across every day of a person's life. The quantity of information that modern location services collect from a single device in a single week exceeds, by orders of magnitude, anything the third-party doctrine's original cases contemplated. The Supreme Court recognized this distinction in Carpenter v. United States, decided in 2018. The court ruled 5-4 that historical cell site location information, the records of which cell towers a phone had connected to over a period of time, was protected by the Fourth Amendment, even though it had been held by a third-party carrier. Chief Justice Roberts, writing for the majority, Observe that location data of this kind is detailed, encyclopedic, and effortlessly compiled. It reveals not just where a person has been, but the pattern of their life, their religious practices, their political associations, their medical appointments, their personal relationships, the full architecture of their private existence mapped against geography and time. Carpenter did not resolve the geofence warrant question. It established the principle that the third-party doctrine has limits when the volume and intimacy of the collected information is sufficiently comprehensive. What it left unresolved is where precisely those limits fall when applied to a warrant that collects location data not for one identified individual over time, but for every individual present in a defined space during a defined period. That is the question now before the Supreme Court in Chaudhry v. United States. The Chaudhry case involves a geofence warrant issued in connection with a federal investigation. The warrant defined a geographic boundary and a time window. Google produced location data for all devices present. The defendant's device appeared in the returned data. The government de-anonymized the device, obtained the defendant's identity, and used the location data as evidence in the subsequent prosecution. The defendant challenged the warrant as a violation of the Fourth Amendment's particularity requirement and its probable cause standard as applied to the individuals whose data was collected without individualized suspicion. The case has produced a circuit split that makes Supreme Court resolution not merely appropriate, but necessary. The Fourth Circuit upheld geofence warrants in Chaudhry. The Fifth Circuit, evaluating a challenge to warrants used in a different investigation, reached a contrary conclusion, finding that geofence warrants as typically structured fail the particularity requirement because they do not describe the persons to be searched with any specificity. They describe only a place and a time, and then collect data on every person who happens to occupy that place during that time. That is not particularity. That is a dragnet. The Supreme Court that will decide Chaudhry is the same court that decided Carpenter, with modifications. The Carpenter majority was fragile. 5 justices agreed on the outcome, but the reasoning did not produce a durable, broadly applicable framework. The concurrences and dissents revealed deep disagreement about how far the privacy principle extended and how the third-party doctrine should be modified, if at all, for the digital age. Draft assessments from Fourth Amendment scholars tracking the Chaudhry briefing suggest that the outcome will turn on how the court frames the unit of analysis. If the court asks whether geofence warrants violate the Fourth Amendment rights of the eventual suspect, the person whose device was ultimately identified and de-anonymized, the analysis looks different than if the court asks whether geofence warrants violate the Fourth Amendment rights of the entire population swept into the initial data collection. Every person whose device appeared in the returned data was searched, in some meaningful sense, before any individualized suspicion attached to them. The second framing is the one that carries the broader structural implications, and it is the framing that makes the Second Amendment dimension of this question visible. Law enforcement agencies have used geofence warrants at locations that are themselves constitutionally significant. Gun stores are legal businesses. Firing ranges are lawful recreational facilities. Hunting areas are public and private lands where millions of Americans exercise legal rights. If a geofence warrant is issued at any of these locations, in connection with any investigation that identifies the location as potentially relevant, the returned data constitutes, in functional terms, a record of firearm-related activity for every individual whose device was present. Repeated use of geofence warrants at these categories of locations, across multiple investigations over time, produces something that no statute has authorized and no court has approved: a de facto registry of individuals who frequent locations associated with firearm ownership and use. The data is not labeled as a firearms registry, it is not stored as one, but it functions as one. The government possesses, in the aggregated returns from geofence warrants issued at relevant locations, the ability to identify individuals whose location patterns indicate regular firearm-related activity. The same logic applies to places of worship, to political campaign offices, to medical facilities, to legal aid organizations, to any location whose regular visitors share a characteristic the government might have reason to document. The geofence warrant does not care about the nature of the location. It collects from the space. What the space reveals about the individuals present is a function of what they were doing there. And what they were doing there is frequently information they have a constitutional interest in keeping private. Carpenter established that the comprehensive, detailed nature of location records changes the constitutional analysis. Chaudhry asks whether that principle extends to the mechanism by which location records are collected, not just from identified individuals over time, but from entire populations across defined spaces. If the current trajectory holds according to early indicators from the court's recent Fourth Amendment jurisprudence, the decision in Chaudhry will not produce a clean, simple rule. The court's digital privacy cases have consistently produced fractured majorities, narrow holdings, and explicit acknowledgments that the full implications of the technology have not yet been resolved. What Chaudhry will produce, at minimum, is a framework for how lower courts must evaluate geofence warrants going forward. And that framework, whatever it contains, will determine whether law enforcement retains the instrument in its current form or must restructure its use to satisfy constitutional requirements. The geofence warrant has been used more than 23,000 times by federal and state law enforcement agencies in documented cases between 2018 and 2023. That figure represents only the requests made to Google and only those captured in disclosed records. The actual number of geofence requests made to all technology companies maintaining location databases is unknown. There is no comprehensive federal registry of geofence warrant usage. There is no mandatory reporting mechanism. There is no public accounting of how many individuals have had their location data collected by law enforcement without ever being identified as suspects, without ever being charged with any crime, without ever learning that their movements were examined. That is the condition of the present. A legal instrument that sweeps the location data of entire populations from defined spaces, used tens of thousands of times with no comprehensive public record of its use, is now before the Supreme Court for the first time. The outcome will either constrain the instrument or confirm it. And confirmation in constitutional law is not a temporary outcome. Confirmation becomes the baseline from which the next expansion begins. The next capability, the next data source, the next investigative technique that collects from populations rather than individuals will be measured against whatever the court says the Constitution permits in Chatry. I have watched baselines shift before. I have watched the confirmation of one instrument become the foundation for the next. I'm documenting this moment because the decision, when it arrives, will be described in terms of the specific facts of one federal investigation and one defendant's location data. It will be narrow in its language and comprehensive in its consequence. The narrow language will be what gets reported. The comprehensive consequence is what gets lived. Every person whose device passed through a geofence boundary in the last 5 years and was collected into a law enforcement database without their knowledge, without individualized suspicion, without any subsequent notification, they are already inside the system that the court is now being asked to evaluate. The court will rule on whether that collection was constitutional. It will not rule on how to undo it. That is the condition I am documenting, not what the court will decide. What has already been collected